The learned solicitor general is for this case? Yes, sir.
Yes, sir. Subject to your lordship's convenience.
Yes, we'll start. Yes. So this is in the first list.
Yes,
we'll start this.
Yes. I'm grateful, my lord. I'm appearing in person before your lordship for the first time. It's really a privilege, my lord. I was looking forward to.
Yes, sir.
Lord, I'll be very brief because your lordships are aware of
Yes, sir.
broad conspectus of the facts.
Yes.
But from the petitioner's perspective, your lordships have also dealt with, my lord, the issues as, my lord, judgments, my lord, which I'm going to refer.
Yes.
So I'll not read. I'll just say the propositions which your lordships have already read.
Yes.
Lord, my submissions are going to be, my lord, in 5 compartments. First, the
Settle. Yes. Settle down, sir. Yes.
yes, yeah, please.
Yes, sir.
Kindly permit me to show from the order which is under challenge. Page 40 vacant.
Which the impugned order?
Yeah.
I don't know, sir. You are appealing for petitioner. Oh,
Page 41 starts. Kindly come to page 42.
Yes.
It reads like this. Petition from Sri T.J. Abraham seeking grant of sanction for prosecution Sri Siddaramaiah, Honorable Chief Minister of Karnataka, for commission of offences under Section 7 so and so of the Prevention of Corruption Act. Kindly mark the next page. Sections 59, 61, 62, etc., of Bharatiya Nyaya Samhita. The said petition seeks sanction, etc. Now, after this, there is no reference to any provision of either the Indian Penal Code or the BNS Act. And sanction is given to prosecute under these provisions. Now, as this Honorable Court is very much aware, these provisions came into force on 1st of July. The last of the alleged acts against the petitioner's family, not against the petitioner's family, ended on 5/1/2022 when the allotment of sites was made. Admittedly, on that date,
BNS was not there.
was not there. How can there be a prosecution of under a law which kindly permit
No,
me
you're
to show?
talking of post facto law.
Article 20 may kindly.
Yes, yes.
I agree. It cannot. It has to be prospect. I have an answer to that. Though
So,
Dr.
but
Singhvi
post
didn't
facto law,
argue.
that is,
Yes.
That
So
is-
Article 20 it died.
that's all.
Now this has 2 limbs. Number 1, it is hit by Article 20.
All right.
Number 2, His Excellency the Governor does not even whisper about this aspect of the matter. He could have applied his mind and said, this is relatable to provisions under the IPC Act. These are the provisions, etc. He could have said it, all right, notwithstanding the prayer. But that is not the case here. Since there is no mention of any one of these provisions in the entire body of the order of the governor. So on that count alone, this order has to go, is my very respectful. And the second aspect is that ultimately all the allegations are against Parvati and her brother. Not a single allegation against the petitioner. As having passed an order, having taken a decision, made a recommendation.
Elaborately submitted.
That is,
yes.
no, the point I am submitting is there vicarious liability of a husband for the deeds of either the brother-in-law or the wife? That's a short question.
No, that stage of drawing in vicarious liability on investigation or on something else has not yet arrived.
Satisfied
Well,
that husband is liable for all the acts of his wife or her brother. If he is satisfied, yes, sanction can be given.
But the scheme of the architecture of
Bias obligation is well understood. But there is no such
highest obligations are well understood.
Pious
Not-
obligations, yes. Yes, sir.
But husband's obligation for the crimes of a lady.
That means we'll hear this also.
So one of the pious obligation on the lighter side
Yes.
is not to shift a criminal liability on the wife.
To take on himself.
Yeah, yes, that is one of the pious. That is on the lighter side.
Yes, yes.
Yes. Lord, my submissions are, my Lord, in six compartments.
Yes, sir.
Lord, first, Lord, the arguments are advanced about the scope of the governor's power under section 17A,
Yes.
relying upon the parameters prescribed under section 19.
Yes, sir.
Lord, I would wish to assist your lordships on the question that section 17A stage
Yes.
and application of mind. Well, I'll take your lordships through, my Lord. I'm just giving
Yes.
outline of what I'm respectfully assisting your lordship with.
Yes.
What are the differences between the provisions of 17A and 19, and resultantly, what will be the parameters of governor's jurisdiction, governor's power, or governor's duty, whatever we may call it, while exercising powers under 17A or 19? Second, my respectful submission is that the parameters of the governor's jurisdiction under 17A would be akin to what is described by the Honorable Supreme Court in Lalita Kumari's case. That he has to see a prima facie case whether the facts emerges a cognizable offense or not. If the facts reflects commission of a cognizable offense, he is not a judge. He is not supposed to sit in appeal and decide whether offense is committed, not committed. He has to say that yes, as alleged, there is a cognizable offense, and he has to discharge his function under 17A. Third, the decision of the governor, because of two reasons, by the virtue of the office he holds, and he deals with, my Lord, other constitutional functionaries generally, and considering the very nature and scope of section 17A, is such that his reasons, which are recorded in the order of approving 17A investigation, need not be elaborate. It must reflect application of mind nonetheless, because any elaborate reasonings will have a tendency of prejudicing the potential accused during the investigation as well as during the trial. But I must show, it's the duty of my Lord the Governor to show that there is an application of mind, and thereafter the reasons are recorded, and the reasons can be found from the file also. The next submission, my Lord, which I am making, Lord, my learned friend's argument was that in case of one complainant, the governor issued notice. In two cases, the Honorable Governor did not issue notice. Lord, my respectful submission in law, and which I will substantiate by, my Lord, the provisions as well as the legal interpretations given by the courts,
Yes.
that at the stage of 17A, there is no requirement of any principles of natural justice.
Yes.
He may have chosen to issue notice in one case, but non-issuance of notice, even in that one case, would not have created any prejudice to anyone, because in law, there is no contemplation of hearing. And I will elaborate, my Lord,
At the stage of 17.
at the stage of 17A. Because Supreme Court has went to the extent of saying, even at the stage of 19, hearing is not required.
Yes.
Yes, because 19 is post-investigation.
Yes.
Lord, next contention I would, my Lord, assist your Lordship with is why the governor was required to act in his own discretion and not, my Lord, as per the aid and advice, as, my Lord, contended by the petitioner. Aid and advice of the Council of Ministers under Article 163 of the Constitution will have no application when the Honorable Chief Minister is facing an allegation. I'm saying only allegation.
Yes.
It is yet to be decided. And the governor is called upon to decide 17A. Lord, the submission, my Lord, which my learned senior, my Lord, just now made,
Yes.
Professor Ravi Kumar Verma, my lord, a very eminent counsel, my lord. I have had an occasion to oppose him in one of the reservation matters before the Constitution bench. My lord, the submission is that mention of BNS vitiates the decision of the governor. My lord, that submission is required to be, my lord, only pointed out to be rejected for the simple reason that suppose IPC offences are also mentioned. The governor will not go under 17A which offences are made out. Then he would add it. So mention of BNS, IPC or any of the sections or non-mention thereof would not vitiate the order. In any case, will not cause any prejudice to the petitioner so as to give him an opportunity to challenge it on that ground. And last, my lord, which again, my lord, my learned senior friend, my lord, mentioned that the criminal liability of the husband, of the wife, cannot be attributed to the husband. Dr. Singhvi also made a submission that I have not made any recommendation. If that is so, then fine, then 17A is not required. The complainant can straightway proceed with the criminal complaints. Then 17A goes, my lord, their problem is solved. They should withdraw the petition that I have not done anything in my official capacity. I have not recommended anything. I am not involved. Maybe my wife was beneficiary. All right, then 17A is not required. Then what are we arguing for? Why are we troubling your lordship with? By showing justification for validity of 17A order. Look, it's a self-defeating, suicidal argument, in my respectful submission.
ವಿಶ್ವ ಪ್ಲಸ್ ಜನಹಿತಕ್ಕಿದು ಜ್ಞಾನದ ಜಾಲ.